Hi, welcome back. What's up, guys? Welcome back to Keeping It Legal, where we break down the immigration laws so you all could stay off of Google. I am Hugh Hudson, and this is my co-star Shantae Wilson.
Hi,
We
guys.
are from the Hudson Law Group.
Yes, and welcome back to another interesting video. Today we'll be talking about the defenses to deportation. We also have some questions from some of our viewers. I'm pretty excited for that.
That is true. Today we're gonna get into the defenses. Um, Defenses will obviously come once you all have, once someone has received the notice to appear, the NTA, to go in front of an immigration judge. Typically, the way that process works, you will receive the NTA. You will reach out to an attorney like myself. You will come to my office for a consultation, and then during the consultation, we will assess your situation or circumstance to see what's the best defense so we can defend your deportation proceedings. So receiving the NTA is not the end of your journey. You still have rights.
You do have rights.
And oftentimes with the right representation, you will be able to defend that deportation.
Yes. So let's start. So one way in which you can defend your deportation, we spoke about it in a previous video, is applying for asylum or withholding of removal. Now, while this is pretty self-explanatory, let me just give you a short synopsis. You may defend your deportation by applying for asylum based on the 5 protected grounds.
Yeah, I feel like we are all asylum out. We've talked about asylum, withholding, removal in length. So feel free to look at our previous videos. So we'll kind of just keep it there and move on to some of the other ones. Do you know a few of the other defenses that we assess when we meet with potential clients?
Yes, another way you can defend your deportation is cancellation of removal.
Yep, that is a big one. So once Shantae has given you the list, I think we're going to pick a few of these to where we're going to go in more depth, as some of them are pretty self-explanatory, like you mentioned. So we'll just go through the list, and then we'll pick a few and then go into some more depth as far as the requirements for those.
Okay. So
what does he got?
So you have, okay, so let's start over. So you can apply for an asylum or withholding removal, apply for cancellation of removal. You can also apply to adjust your status, apply for a U visa or a T visa, apply for certain waivers based on certain conditions. I know you can also apply for a constitution or procedural removal, and then also TPS.
Yeah, TPS and DACA as well. I'll go in a little bit on DACA. So DACA is a protection to which President Obama he instituted a policy to where he determined that there are certain non-citizens who have been brought to the country as children. Right? Obviously, they didn't have a choice. They may have come with their parents at age 2, age 3. And they've been in the U.S. for years. Some of these individuals believe that they're U.S. citizens. They've been here since they're 2, now they're 25, 30, and without any protection. So President Obama had passed a policy to where if you're in the country at the time the law was passed, which you can double check my date on this, but I believe was in 2012, in September of 2012, and you had been in the country and you came as a child, then you can apply for defer action against deportation. So essentially it's DACA, because they are, and that is a protection from deportation. Essentially it says that if you fall into this category, you cannot be deported from the United States. All right, so that's DACA. I'll let you choose. What are some of the other ones I should
discuss? A popular one that that gets mentioned a lot during your consultations is definitely cancellation of removal.
Yeah. So cancellation of removal is if you have been in the U.S. For at least 10 years, and that will be 10 years prior to the NTA being issued, and you have good moral character, you can then apply to cancel your removal. There's 2 types, matter of fact, 2 types of cancellation or removal. One for lawful permanent residents who could be placed in immigration proceedings, and also for non-citizens or people who are here undocumented. Right? For the lawful permanent residents, the physical requirement is 5 years as opposed to 10, right? So you have to have been physically present in the United States for 10 years. For undocumented folks, you must have been present for 10 years. You have good moral character, and you have a qualifying relative. What a qualifying relative is either that person has to be either a U.S. citizen or lawful permanent resident, spouse, or a child that will suffer extreme hardship should you, the immigrant, be deported or be forced to leave the United States. And because of your absence, they will suffer extreme hardship. I would say that the word extreme is there for a reason. There was actually a Supreme Court case ruling on this. So that hardship has to be more than just the regular companionship, like I'm going to miss my spouse or my spouse provide for us financially. The most standard, straightforward, qualifying relative are individuals who are sick. If you have some kind of disease or illness and you are reliant on the United States healthcare system, and your spouse is your support system, for instance, your spouse helped you go to, let's say, if you're as an immigrant, you're seeking, you've been diagnosed with cancer, right? And obviously your spouse is there. She takes you to your hospital visits. So if that person is no longer in the U.S., then you will not be able to survive. You will suffer that hardship because you will lose your support system. And on the other hand, if you choose to return to your spouse's home country, you will also suffer because you will not be availing yourself of the type of medical attention that you will need in order to survive. Right. So that's typically how the hardship is met. And obviously good moral character. You have to show things like you haven't committed any crime,
pay your taxes,
you've been paying your taxes, and things like that.
Another popular one is adjustment of status.
Yeah, so we're going to be doing an episode on adjustment of status because that's probably the most popular immigration benefit that our clients apply for. So it kind of deserves an episode of its own. But to touch, for the sake of defense, if you are in the U.S. and you have an immediate family member who can petition for you, an immediate family member will be a spouse, a child over 21, or if you are a child younger than 21, a parent, the United States citizen parent. Those individuals could petition for you, and you will be able to adjust your status in front of an immigration judge for in the deportation proceedings. Again, we're going to touch on adjustment of status on a subsequent video, and we're going to get into a lot more details on it.
Let's touch on the last one before we go to our questions that some of our viewers sent in. Let's talk about on a constitutional procedural basis.
So constitutional procedural basis, there are certain requirements that needs to be followed, i.e. that's what the Constitution is. So if your constitutional rights are violated, an immigration judge or sometimes DHS, they will choose to dismiss your case or just grant you a particular status. I'll give you an example. There is a Supreme Court case that says if an immigrant rather is charged with a crime, that either the DA, the prosecutor, or the judge is constitutionally mandated to explain and instruct that immigrant on the consequences of taking the plea deal, right? And if that is not done, you are put in proceedings as an immigrant, you can then seek a post conviction dismissal. So essentially, the judge or the DA has placed you in a place where you are now in deportation proceedings because of their negligence or inability to advise you on your rights. Then an immigration judge could dismiss your case because of that. Because it's important. Certain pleas, depends on what the allegations and the charges are, could lead you to deportation proceedings for instance, if you plead to a crime against moral turpitude, like a theft crime, larceny, robbery, or something to that effect, and you aren't aware that could lead you in immigration proceedings, and you take the plea, then you can end up in immigration proceedings. So what that Supreme Court says is that the judge has a right to then let you know, if you take this plea, it could impact your immigration status.
Okay. All right, we'll jump into our questions from our viewers. I must say, guys,
can we talk a little bit about U visa? And I think U visa as well. We're going to do an episode at some point.
Sure.
But that's also, it's also critical. U visa is if you as an immigrant has been a victim of a crime. Certain crimes, there's a list of the eligible crimes. Domestic violence is one of them. Stalking. Being a victim of a dangerous felony, like armed robbery and things of that sort. You can you can file for a U visa, right? And if you have a U visa pending, then the immigration judge tend to dismiss your case and allow you to remain in the U.S. because a U visa grant will protect you from deportation.
So what's the difference between U visa and T visa? Because I see that as a way that you can apply to defend your deportation.
Yeah, so T visa also require you to be a victim of a crime, but T visa focuses more on trafficking.
Also, they're different crimes.
Okay. Yeah, they're different crimes. So if you are a victim of traffic, there are some people and organizations that will falsify certain records or entice immigrants to come to the U.S. under false pretense. Like there's a case that I worked on where this was an Indian company that was bringing Indians to the U.S. under the false pretense of that they'll be working on the ship. There will be sailors on the ship, and then once they're in the U.S., they subject them to forced labor in the restaurant. So they were working these individuals 24/7 a day in the restaurant, and obviously not paying them as much as they should have, right? So that ended up leading to a T visa. You have to, for the T visa and U visa, there's a component of law enforcement. So these are crimes that you as an immigrant have to report to law enforcement, and then you have to participate in the investigation and or prosecution of these individuals.
Okay. I got so excited about the fan questions because, I'm really happy that you guys are tuning into us weekly to listen to us, sit here. And I'm really happy that you find us both educating and also entertaining.
Absolutely. It does take some sort of work to take the time out to do this. So we are appreciative of the responses and the love.
Alrighty, so are you ready? All right, so our very first question is from Maria. So Maria says, can I get a green card if I'm placed in deportation proceedings? First of all, thanks for the question, Maria. Now over to you, Mr. Hudson.
Yes, so you could, several of the defenses I mentioned could lead to, or will lead to a green card. The most probably the quickest out of the ones we mentioned today are the adjustment of status. That's a green card. You're adjusting your status to a green card.
Right.
Cancellation and removal as well. Cancellation and removal, there is a wait period because there are a limited amount of visas allocated for that category. So it may have to wait a year or so after the judge's order. Asylum as well. After you've had an asylum grant for a year, you're able to apply for asylum. U visas as well. U visas take a lot longer. There's also a cap on the amount of U visas that are allocated per year. So the wait time for U visas is substantial, 4 to 5 years. But you're able to legally remain in the U.S. Until a U visa is granted. And then once the U visa is granted, you can then file for your adjustment of status within, I believe, is 3 years of receiving that U visa. The U visa grant will be good for 3 years, and you can file to adjust your status. I think that's it as far as the green card. The rest of them will lead to deportation protection. DACA leads to deportation protection, but not a green card. TPS as well, and the waivers, and some of these the defenses that we mentioned is actually defenses that lawful people who are already lawful permanent residents could use.
Okay, nice. Another question is from Edgar. So he says, who do I appear in front of once I'm placed in deportation proceedings?
So Edgar, so like the previous video, we talked about the deportation process and where you need to appear. So you will be an EOIR, an immigration court. So you will be appearing in front of an immigration judge.
Okay, and thank you, Edgar, for that question. Judy from Jamaica says, if I miss the 1-year deadline for asylum, am I completely out of luck?
Judy, you are going. So the asylum, the 1-year filing deadline is very critical. However, you could still seek the judge's discretion on whether the judge wants to grant you a kind of a waiver of the 1-year filing deadline. Judges will grant that waiver if you could display that your inability or failure to file was because of extraordinary circumstances that were beyond your control.
Okay.
If you were sick, you were in jail, or something to that effect, the judge could determine that's sufficient for him to waive the 1-year filing deadline. So it's not a hard cutoff, but it is very consequential. These days, judges are all days judges are cranky, but the kind of climate that we're under right now, immigration judges are extra cranky.
Okay, so this one is from Catherine. I kind of like this question, by the way. She said, my cousin filed for asylum and was denied. What is next? Can he still apply for another process?
So if your cousin was denied asylum, it depends. If we're talking deportation proceedings and she was denied the asylum in front of a judge, then no, because when you have your NTA, you show up to that master hearing that we discussed in the previous video, you need to tell the judge your potential claims or defenses. And at that point, your lawyer or yourself will have to let the judge know all of the potential benefits that you qualify for. So if your lawyer failed to disclose something that's a benefit that you may be qualified for, then that will be ineffective assistance of counsel. And at that point, after the judge enters the decision, you would not be able to apply for any of the benefits. You certainly could appeal. You can appeal a decision to the Board of Immigration Appeals, and then one of the federal courts if you are still unsuccessful and unsatisfied with the decision of the BIA judges.
Okay, alrighty. So Kenneth says, I don't think my country was on the news for war or violence. Can I still qualify for protection if I apply for an asylum?
So that's a good question. That is very good question.
Yeah.
Because people kind of infer that if a country is at war or there are a humanitarian violation, then you automatically will be granted asylum. That's not what asylums are for. I always tell clients when I have consultation that there are countries where there are extreme and very severe human rights violations, but there are also people in those countries that are living lavishly, like they're living the life. I'll give you an example. Mexico is a beautiful country. There's a lot of tourism. There people go to Mexico and have a great time.
Yep.
And there are billionaires and millionaires, a lot of them in Mexico. But there's also a lot of Mexican citizens who are struggling, who are fearful of being killed or severely harmed, right? So the country could be bad, or a segment of that country could be bad, but there are people within that same country that is living life.
Good. Yeah.
My point in saying all of this is that asylum is specific. You have to specifically establish that you yourself will be a target should you be returned to your home country. But yes, certain countries that are known for their human rights violation increase your chances because depends on the persecution that you face. If it is common knowledge that this happens or this occur in that country, then it could increase your chances. But yeah, you can be from England, right? But if you are being persecuted and you have reason to believe that you yourself will be harmed or persecuted should you return to England, then yes, you could then apply for asylum.
I realize that most of our questions are what we got from our viewers are from asylum. I guess our asylum video.
I guess they aren't asylum out. But yeah, it is a very big topic, and it's you know,
keep the questions coming, guys. Yeah. All right, so another one. If someone, this is from Anonymous, I guess they don't want to be known. If someone wins withholding of removal, can they ever travel outside the U.S. again? Ugh.
Unfortunately, no. Withholding removal is, and this is why it's like a default status. Withholding removal is just what it is. You have a removal order, is for one reason or the other, your removal is withheld, but you're not able to travel outside of the U.S. Then you always could travel outside of the U.S., but you will not be able to return to the U.S. So no, to that question. I have an interesting case of mine where we were granted withholding removal for an individual whose country no longer exists. So that person, we would assume, would be in the U.S. forever, but they aren't able to travel to any other country. It's one of those countries that Russia annexed. So the country is no longer in existence, but her status is still like withholding removal. Well, unless a judge were to reopen and terminate her case, and then she were to like get married or something to that effect.
To adjust her status.
To just adjust her status, yes.
All right, to me, but definitely. How do judges decide if someone is telling the truth in court, Mr. Hugh?
So this is my favorite. But no, so I know when...
This don't have a name on it, so shout out to whoever you are.
I know when I consult with potential clients that I always let them know. Matter of fact, I have a quote on my in my office somewhere that says, the ultimate form of credibility is corroboration, right? Now, if you have evidence corroborating your stories, then the judge will believe you. If you're saying that you were hurt or harmed because of your political affiliation, and then you have your voter registration card to show the political party that you belong to, and you have hospital records to show that you were harmed, you have a police record to show that you went to the police and you told them about your harm, then they will believe you. If you don't have any evidence and you're just up there talking, you're going to have a tough time, because for one, it's going to be an environment where you will at some point crack, because the judges, the opposing counsel, DHS, they will ask very tough questions. Judges ask very poignant questions, like they're trained in this. They do this every day, and they've seen it all. So they're going to ask you very poignant questions, and you are eventually, your story will not hold up. So I wouldn't represent anyone if I feel like they're lying or not telling the truth. But you will just make things difficult to yourself. But to answer the question, have evidence. If you have some evidence, the judge will likely determine that you're telling the truth. Is that it?
Yep, that was our last question. I like that question too.
That is a good question. Good way to end.
Yeah, got right to the point. Well, if you or anyone you know need any immigration advice, please feel free to reach out to the Hudson Law Group. We're ready to serve.
Yes. As always, thank you all for tuning in.
Yes, I think this was a very concise video.
It was meant to be. We kind of went on longer. We just kind of wanted to piggyback from the deportation proceedings video we did, because we felt as though we left you all unfulfilled. Yes. So we kind of wanted to piggyback off of that. So you all could look at this video as Deportation Proceedings 2.0 or part 2.
Yep. And keep the questions coming, guys.
Yes.
Really good questions.
We are going to be back soon.
Yes. Bye, guys.